From the western part of Kenya, I am Robert Wanyonyi, and this is KTN News.
This is KTN News.
Mark, please first. Welcome back. You're watching this extended version of Kivumbi 2017. We have just seen the final submissions at the Supreme Court. The 7 judges of the highest court in the land now retreating to write their rulings. Kenyans expecting a verdict in the next 3 days or so. I'm now joined very quickly by lawyer Joy Brendam Devo and communication strategist, expert Mark Bichachi. Thank you, lady and gentlemen, for joining me.
Thank you for having us.
We have seen a lot happen in the last 3 or 4 days. How would you describe the performance of both legal teams?
One thing that we must give credit, where credit is due, is that both teams, not both teams, because there are actually quite a few teams that presented,
right.
Everybody did their homework. With the time constraints that they were given, with the parameters that they were given within which to work, we saw a lot of preparation going into it. Most of the teams were also very well coordinated because you saw, for example, you have 5 hours to fill. You cannot expect one advocate to carry a train of thought through those 5 hours. So they were able to section the arguments and be able to deliver the punches that they needed to deliver. So that much you must give them credit for. Somebody like the Honorable Attorney General is known for being able to talk for quite a while, but you saw him today being able to take his 20 minutes, punch what he needed to punch, make his point and get out of the way. Also, we've seen the court, how it has been conducted. The judges have had a very even keel. They've been very balanced in the rulings that they've made, even on oral applications in court. And they've also had a firm hand on the procedure and what has been going on in court. So the litigants have sort of not been running the show, as it were, but even where the litigants seem to step out of line, the Chief Justice or the Deputy Chief Justice were very quick to establish the order and bring everybody back in tow. So the last 3 days we have seen litigation par excellence, I think.
All right. Mark, what stood out for you?
I think the most amazing thing for me is that Kenya is actually coming out as the winner, in the sense that both sides have argued the case that will end up in helping build our democratic institutions and our democratic conversations. This is very critical because the Kenyan people are now informed between what was innuendo and what has been fact. And the people are able to decide. And as the courts give their decision, the people are able to interact with the electoral processes and be able to query for 2022, for a by-election coming up. We are able to query and build based on the information that we've received. And I must commend the panels that were there, the various lawyers, because they came out very articulate, the judges were very firm, and they seemed also to be very fair, which is a very important thing. Right. So I think on the whole, the picture is that, number one, Kenya is coming out as a very clever country. Let's start there. We sound very, very smart. Let's start there. And two, the points were argued from a basis of sense and where the basic human Kenyan can relate with the points.
All right. Of course, some of the issues that Kenyans expected or did hear was the report on those on the audit of the servers by IEBC and what the teams had to say about that, as well as the forms 34A and B. Let's listen into some of that.
This is our own independent expert saying, and does not affect the vulnerability of the system. And they conclude by saying the internal firewall configuration was not delivered as ordered by the court. My lords, that's serious. My lords, in regards to certified copies of certificates of penetration tests conducted by the IEBC on the election technology system prior to the election. My lord, again, this one was not submitted at all. And this is important to know whether this system had integrity. My lords, again, when it comes to the documents relating to certified copies of certificates by professionals prepared to Regulation 10, again of the same regulation, again, this was not provided. This is even more important, Order 1, found in paragraph 3.9. Specific GPR location of each KIMS kit used during the presidential election for the period between 5th of August 2017 to 11th of August. They said they provided the GPS locations for the polling stations, but not for the kits, which means that if those were provided, then they would have known whether these kits were used or not and from where they were used.
All right, that is the lead counsel for the petitioners, that is a senior counsel, James Agri Orengo there. Of course, on that, the audits of those servers and all that, there was an issue about reports that Orengo was referring to. Joy, I don't know if you can just clarify for us.
What we saw is Honorable Orengo was looking at a report when he was making his submissions earlier. And we saw a challenge coming from Ngati on the other side saying, look, the only reports you should be referring to are the reports that we have. Now, the difference with that is, while they were going to the scrutineering, they went together with the registrar of the Supreme Court, as well as court clerks and court staff from the Supreme Court, as well as court-appointed IT experts. Now, the report that was generated by the registrar is what the judges will rely on, because basically the registrar was their eyes in that scenario. So rather than the judges themselves going to take evidence from the servers, the registrar did that on their behalf. And then why they had the court-appointed IT experts, so that you have a third eye that is looking at the system and can draw a conclusion as an expert. Now, we saw the ruling by Judge Lenaola had some expert input, and I understand that the thicker version, that because there are two reports, the thicker version is the one that has a technical aspect into it. So that's why there was a distinction between the report that Honorable Orengo was trying to table and what he finally ended up having to rely on, because the judges will only look at the report from their own officers as well as their own court-appointed experts in this matter. But each of the parties was welcome to produce their own report.
The report. All right. Speaking of IT, a lot of conversations on social media, especially Kenyans, were talking about servers, the IBC servers. There was a lot of conversation of some of the legal teams saying that we were relying on Europe, and Europe, they were still asleep. Much of that conversation. Without getting into the detail of this case, Mark, what should Kenyans know about servers?
You know, one of the things about server technology and how they've been set up is, whereas you can read and write into the servers, it is very hard and almost impossible to totally get rid of the server logs. Now, what server logs are is a record of everything that has happened on the server, and they are made that way so that in case of any inquiry, there's the ability to check and audit. And I believe in this particular case, based on the report that the court-appointed IT officer has been able to give, they should be able to give a detailed record of what happened with those servers, whether local or international. And that really should be a good thing for the Kenyan people, because we will be able to establish what is fact. And that's a very good thing, because server technology as it stands today, even hackers will tell you the hardest thing to touch is removing the records. You can get in, you can get out, but to remove the record of you getting in and getting out is nearly impossible.
All right. Joy, is this server issue very critical to the case?
Yes and no. It is good because it is corroborative evidence. It goes to support the other allegations that have been made. Now, we've had a lot of talk about whether is it the numbers, is it the what, but at the end of the day, if you're making an allegation, for example, of tampering, it goes to the tampering of the communication system. But now that has to go hand in hand with what they also have in hand as the physical copies. So that how you build evidence is one piece of evidence, corroborates another piece of evidence, corroborates another piece of evidence. So in the big picture, it's actually a very critical piece of the puzzle. But we will not know its significance until all the evidence has been analyzed. Because at the end of the day, part of the allegation that I had, part of the submissions that I had Honorable Mute making was, you know what, there could be this and that, but does it affect the result at the end of the day? That's a critical factor because that's what the LSK was supposed to be submitting on. At Section 83, is the will of the people still heard or is it subverted? Because if it is subverted, then it means the errors were big enough to not be ignored. If it was not subverted, then now the court has to give direction on then how do we treat all these discrepancies.
All right.
So it's a very critical piece because all along NASA has been saying we need to get access to the servers, we need to get access to the servers. Now that it has come out, I'm really looking forward to seeing the report because now that will tell us, by the way, whether all the rest of the case that they have been building actually adds up. So it's a very critical part.
All right. Mark, speaking from your IT background, were there enough ICT experts and all that in this petition?
It's difficult to tell because it depends on the intelligence and the capacity of the guys. If there was a hack, what level of proficiency did they have? If it was a low-level hack, then it is very easy to detect. If it was a high-level hack, then it takes longer to detect. Now, what is going to be the proof in the proof in the pudding in this particular case is going to be the scrutiny of the wider report that the judges have received. Because then you've got, again, like Joy said, there are two kinds of evidence located within the server. There's the actual forms and the actual data as presented. Do they show any form of manipulation? And then there is the logs. Do they show footprints of manipulation? So the logs are complementary evidence to the factual evidence that is the data and the forms that are held in the servers. Now, the forms and the data form the primary evidence as far as this IT case is concerned. But the logs give you the footprints of what happened. Now, it will be difficult to say at this time whether they had enough time and indeed proficiency to determine what really happened. Because, again, it depends on the kind of breach. You know, it's like someone who breaks into your house and you can find the padlock is broken, the window is broken. You can definitely tell someone came in. But if you find it was a cat burglar and you don't know where they came in and you don't know what happened and you just have a phone that is missing, you will keep wondering, did I lose it in the matatu? So those are the questions really that will be looked at in this case.
All right, as Kenyans await that verdict by the 7 judges of the Supreme Court, they will be thinking about the 2013 petition, obviously. Joy, from where you sit, what are some of are there any similarities to the case in 2013, or what are the major differences? It's a different bench, obviously, the way it's constituted and all that.
Yes, and at that time, the bench was relatively new and, allow me to use this word, inexperienced, because we had the judges who had just come in, they had not yet quite formed, a unit, as it were. This particular time, and in this instance, now we are dealing with people who are, it's a bench that has been there for a little while together, and they have also had more seasoned judicial officers joining the bench. People like Judge Lenaola, in constitutional law, nobody holds a candle to him. Judge Maraga has also been in the judiciary for quite a while. So you find that the type of judges we're dealing with now and what we had in 2013 are two different, completely different benches. We're also dealing with a legal regime where we've had a lot of electoral reform. Since then and now, we've had changes to the Electoral Act, the Act itself, to the rules. We've recently had amendments that were made just before this particular election cycle. Also, the Constitution at that time was a little bit newer because 2013 was about 3 years old. By now, it's about 7 years old. So we've tried it a little bit more for size. Over and above that, we've seen a higher level of preparedness with the judiciary, with the advocates as well. They've had a lot of training in the new election regime, the evidence, what sort of evidence to lead, so that the type of cases now we have. In 2013, for example, we had very many amicus people who joined in the party and got to a place where they almost took over the show. Yeah. The Honorable Attorney General would have been mistaken to believe he was one of the parties acting. But this time around, we've seen the judges also taking a very firm position, giving time to the petitioners to prove their case and giving the others enough time to also prosecute their matters. So you see this time around how the matter has been conducted. There's a lot more thought process that has gone into it, and it's been a lot better organized, I think, than before. Another difference that we see from 2013 and now is that in 2013, we still had the fear and the trepidation of the 2007, 2008 sword of the Makulis. Now we've gotten to a place where people, you see that in Kenya right now, there's some tension, but people are they're a lot calmer. They're willing to let the court take its process. They're willing to let the process take its course. And that shows also the maturity of the voters, because this time around, we're not seeing as much agitation as we had seen in 2013. But also now for the people who have gone to court, this time around, they're a lot better organized. The evidence was prepared in time, it was delivered in time. What was out of time, there was an explanation until the court was minded to actually enlarge time for them. So we've seen a much better system this time around, better organization, and hopefully also the quality of judgment that comes out this time around will be vastly different from what we had in 2013. Jurisprudentially, it will develop the jurisprudence of electoral laws in Kenya, electoral systems in Kenya.
Mark, what are the differences or similarities from what you said?
Well, the key difference here, of course, is the specificity of the case that is being handled now. I think one of the issues that we had in 2013, if you asked the public, we didn't quite know what we were complaining about, because we had the electronic kits that had failed. We also had black book, green book, yellow book, red book. We had so many issues in 2013 that it was hard to pin down, and I'm speaking from a communication perspective, what one or two issues you would say was being petitioned about. The good thing about this time, where the pleadings are many, but you can basically say, from even a layman perspective, you can count the issues that even have made it onto social media. And that tells you that there is a higher level of intelligence and a higher level of thought that has been put into this petition, which is very, very critical. The second thing that I think is also very important, this petition has zeroed in on what the perceived issues are, which means the natural result will be that we will have a much better, firmer and tighter 2022. The other thing that is very interesting is, and I am very sure that a lot of people who are watching this particular petition and either lost their MP races or gubernatorial races are looking to learn and to see, how do I have an opportunity to petition at my own stage, at my own level, at the High Court. Right. And those are the key differences. And the key difference is in the result. What I feel confident about is because the matters have been so specific, and just learning from 2013 how much there was electoral reform because of that ruling, then I'm very confident because of this ruling, we should have a much tighter electoral system come 2022. And the key thing is here is to always realize that democracy is about improvement. It's constant improvement. From 1992, Kenya has improved, and that's what we need to keep going at.
All right. Joe, you talked about a firmer, better judgment, and a lot has been said about the judgment in 2013, that it was one paragraph, it was so short. What is a good judgment?
No, you know, what happened in 2013, maybe members of the public may not be aware, there was the 6-minute judgment that was delivered on the day. But the judges have 14 days after they deliver that to do their reasoned ruling, the reasoned judgment. And they did that. But you know now, if it's no longer in the public glare, you can imagine that the judgment was what Judge Motunga said. We are pleased to announce that we actually have a result in this matter, and the result is the election is fine. So even on Friday, the judges have that option. They can decide to say, look, from what we have considered, all is said and done, we feel that either we have a unanimous decision that this is the position on issue 1, 2, 3, 4, or we have a majority decision with 2 dissenting opinions, and give you like an abridged version. Because the law allows them to do that if they already have the consensus, so that when they now retire in the next 14 days, then they can do the more detailed judgment, and that is the one that is of interest to us, because that is what will detail what was the problem, where were the shortcomings. These things that we're hearing being said that there are tiny little things, those are the tiny little things that need to be changed even moving forward. So with Kenyans, the problem with the 2013 judgment is that even jurisprudentially, there are some things that it fell short. But as Mark correctly points out, even with its shortcomings, it was still good basis for us to have quite substantive electoral reform. With this particular bench, I foresee a more robust ruling with very good reasoning that will be difficult to argue with. And now, based on that, I'm looking forward also to having a lot more discussion, even in Parliament and out of Parliament, with the jurists on how can we reform our election laws to make more sense? Because we've always had a lot of reforms, IPPG and whatnot. We need to get to a place where let's lock this thing down so that we can say when us, we've gotten to a place, we've graduated from this election law class.
We're there now, yeah.
We're always learning,
All right.
I hope this will be it.
There's a question that people have been asking. Today we did see Judge Mohammed Ibrahim in this, not able to attend. So 6 judges. So what happens? I mean, just for the lay Kenyan out there, what should happen? I mean, obviously we hope that he gets well and all that, but what happens?
He is still a part of the bench because he started sitting with them, so he's still a part of the bench. Today he may have been absent, but the expectation would be as soon as he recovers, then he'll join his brothers tomorrow and the day after to be able to arrive at the final decision, because they need to sit at least 5 judges. So that the bench is still properly constituted because there were 6. And even if they are voting just the 6 of them, the Chief Justice has a deciding vote. So if it goes to vote and there's a tie...
So a number can be even. It can be
so even if it's even, as long as the Chief Justice is there, he can choose to let the other 5 take the vote. But if it gets to a place where it is too contentious, then his vote is a deciding vote. But at the end of the day, I would expect that if Judge Ibrahim is feeling better tomorrow, because remember, this thing has been done so quickly that if you miss one day, you've missed half of the show. But tomorrow he might be better, and while they're retiring to consider the evidence, he will very well join them. So I don't think it does not vitiate the process in any way, because he's human. He's allowed to have a sick day.
As we wind up, Mark, you've said something about the electoral process and what Kenya has learned. There are those people who feel that every time you have a presidential election petition, it means that it is everything that is wrong with the system, that it shouldn't happen. Do you hold that view, and do you foresee another petition in 2022, given the trends?
You know, it's a very interesting place to be, an electoral petition, and I was involved in the 2013 one. I was involved in the one in Ghana again, 2013, shortly thereafter. And one of the things that I've learned about petitions and why they're actually very good for democracy is there are 3 levels of things that happen in an election that can be considered mistakes or criminal. The first is human error. Human error is someone wrote 100 instead of 10. You understand? Which can be remedied.
Yes.
Then there is mischief. Joy is my sister. I want her to win, so I played a trick to help Joy. Then there is the overall criminal intent, where nationwide almost you can see a hand being played to manipulate the election. So whereas in any human endeavor you will find certain errors, what a petition helps to do is 2 things. Number 1, you find a remedy for the errors. That is very, very critical. You point them out and you find a remedy for the errors. The second part is you're able, and this is one of the good things about this particular election cycle. We know many people have lost their jobs and even been fired for carrying out mischief in this particular election, and that is a step forward. Now, what the judges will show us is whether there was a global problem, okay? And that is very critical, and that goes down to their ruling. One of the things that I thought, and this is purely from a communication perspective, not from a legal perspective, the 2013 ruling is that it did not communicate and address the issues that Kenyans felt were raised during that petition. It was almost like they were glossed over. What would be a good communication judgment is to be able to address what the public perceives to be misnomers in this particular process and address them with your ruling. It is very, very critical from a communication standpoint. So Are petitions indictments on our electoral processes? No.
Right.
They're actually proof that our democracy works. Let's remember, democracy is not just about electing a president.
Right.
The democracy is about having judges that can do their job, a legislature that can do their job. Democracy is about an army that can stay out of this. That is so critical. And these are some of the things that we need to celebrate.
Right.
That we have a country where, in a situation like this, the army is calm. In a situation like this, the judiciary is working and no judge has written saying I need to be saved because my life is in danger. Those are the things that we need to celebrate.
All right. Joy, as your final thoughts, do you think we'll ever get there where we stop, we say we've gotten there now, we've had these reforms, IPPG, the 2010 after Constitution. Are we likely to get there anytime soon?
We are getting there. We are getting there because right now, if you even look at the overall election petitions, we have what? So far, I think it's about 30 that have been filed, or less than 30 that have been filed in the courts countrywide. It means we are doing something right, that people have got more faith in the process, they understand it better. And even the people who are contesting get to a place where they have a level of trust in what has happened. That is why they're able to accept the rulings. But like Mark has said, there are some of them who are watching this and thinking if there is something that they can pull out of there that would help in their own petitions. But something that also we need to remember is that when we have such cases, and especially for the lawyers who are leading the case, it is important to lead critical judgment.